Chapter 10, Payments and Certificates. Welcome to this episode of our podcast, arising out of the publication of the 4th edition of Wilmot-Smith on construction contracts. I'm here with David Sawtell to discuss Chapter 10, Payments and Certificates. David, this chapter fits essentially into two separate sections: statutory payment and the rules about statutory payment on the one hand, and certificates on the other. Where did you see the meat of the work for the updating between the 3rd edition and the 4th? Which of those two sections was it?
I think it's the more general guidance we have about certificates. What we see is a line of cases about certificates and about the role that the certifier has and whether or not good faith comes into it, and whether or not, how to the extent to which you can challenge the process through which the certifier goes through, coming together in the Supreme Court decision Braganza against BP Shipping in 2015.
Which was just after the 3rd edition, wasn't it?
Indeed. And that was an employment case, but it was made clear by the Supreme Court that what they wanted to do was to try and rationalise the scope of the law, where you have a party who has to make a decision that will affect the rights of both parties. And it was confirmed that you could imply a term where the process would be lawful and rational in the public law sense. And already we started to see that in this edition filter through into construction cases such as Everwarm Limited against BN Rendering Limited in 2019. A case where it was held there was an implied term, a discretionary assessment on provision of a contract would not be undertaken in an arbitrary, capricious or irrational manner. So I felt that was an incredibly important development in how certification works in construction contracts. And I think it's something, particularly in the larger projects, or indeed in more complicated payment regimes in construction contracts, will start to filter through and create a new level of challenge to the overall process of certification.
And do you think obviously there's this great historical debate about whether the amount that's due is the value of the works or the amount stated on the certificate, and we've all dealt with that, and indeed that overflows into the Grove dispute in relation to payment provisions under the Act, and adjudication. But do you see the Braganza and Everwarm lines of authorities as, on the one hand, pulling certification back in and restricting its ambit, but on the other hand, giving it strength as a consequence of its being given the credibility of being required to be reasonable?
Certainly, it's giving an extra veneer of credibility to it. It's no longer the case that what goes on a certificate can no longer be unthought, can be completely irrational, and therefore what goes on a certificate has to be thought through. And I think the line, Paul, one might like to see developed is if a certificate has to be approached in a rational and not in an arbitrary way, is whether then the interim certificate stages get more weight and get more value, and then disputes about any payment notices arising out of that become more inflected with an idea that they are meaningful, rather than simply being numbers on a piece of paper which have automatic contractual results.
Yeah, it's interesting because there's this great debate between process and substance, or between form and substance. And over the sort of scales keep on tipping back and forth between the two outcomes. And people used to think certificates were merely evidence of what was payable, and not binding. And then the law moved on to regard the entitlement as to receive that which was set out in the certificate. And you're seeing this sort of generally converging towards the middle, aren't you?
I think it's absolutely right. Certainly, we've moved a long way from the idea that a certificate could be treated as equivalent of cash, like you saw in one discredited line of authority that went to the Court of Appeal. But we are starting to see a movement towards the middle, probably because certification and cash flow is so universally acknowledged to be fundamental and critical to a construction project, but to any kind of project that relies on cash flow in order for it to keep moving forward.
I like this chapter, talking about it generally, because it those of us who do construction work, valuation and payment is what is at the nub of so much of what we do. And of course, this chapter on the one hand deals with the right to payment under the Housing Grants Act. It looks then at the contractual position, and it grapples with and explains the position about schedules of rates, bills of quantities, milestone payments, final account, and all of those topics. And it gets its hands dirty, in my view, in the valuation process. And that's one of the reasons I like it. Or is that me being over sort of construction law romantic, or is that a view that you would share?
It's a view I share. It was a really interesting chapter to work on, because we're going all the way from 19th century in cases such as Sumter and Hedges, all the way right up to whether or not it's appropriate still to have hybrid payment regimes in power generation and construction contracts, such as we saw in C. Spencer Limited against MW High-Tech projects. So the scope of the chapter within its pages is really quite broad chronologically, but also in terms of importance.
It's interesting with certificates how you see them the courts, different courts approach them at different times, and very much being influenced by things just offset, as it were. For example, the decision of the Court of Appeal in the Northern Regional Health Authority and Crouch case, where the courts were very clear that, or the Court of Appeal was very clear that to open up review or revise a certificate, you had to go to arbitration, was part of the move then to arbitration. Whereas now, of course, the dispute resolution tableau is so very different. On the one hand, you have the TCC doing an absolutely brilliant job with lists that are manageable. On the other hand, you've got adjudication, which attracts the industry's support, and therefore being technical about certificates so as to decide that cases should be resolved outside the courts, which is ultimately what Crouch was about, does seem to me to be quite a significant development. Anything on the horizon, do you think, for the next few years, or do we just have to wait and see what cases pop up, as it were?
I think in this area, it's about waiting and seeing how the cases arise. One thing we might see is whether or not Parliament intervenes to deal with the carve-outs from the Housing Grants Construction and Regeneration Act in terms of power generation contracts. We've already seen a move, just in terms of public procurement in the energy field, towards using waste and other forms of materials, such as biomass, for power generation, and the extent to which it's appropriate to have a binary carve-out for power generation, and therefore we have one contract trying to deal with two different payment regimes and then trying to deal with adjudication at the same time. I think Parliament might have to make a decision on this. I say it might have to, or it might not. Watch this space.
As you know, work on the 5th edition of Wilmot-Smith on construction contracts is already underway. Let's hope the parliamentarians get their skates on so that if they do, we get it into the next edition. David, thank you very much indeed for all your work and help on the 4th edition and for coming to talk to me today. This is obviously an important and specialist area of construction law. It's one of the chapters in the book that I'm particularly pleased with because it seems to me that it's a proper building lawyer's read. And as those people who are buying copies of this book for their summer holidays will know, that's a comparatively specialist cohort. Thank you very much indeed.
Thank you, Paul.